It's 5 o'clock on my clock, so my name is AJ LaRosa. I will call today the July 15th meeting of the Burlington Development Review Board to order. We will be proceeding through the applications in the order they're listed on the agenda. Communications have been posted. We are mostly online tonight with a limited presence. And we'll be taking record of this. The same rules still apply, and anyone who wants to speak will be asked to be sworn in, and we'll go from there. The first item on our agenda is 501 Pine Street, a request by Kurt Schuele, KS Pine LLC, for a 1-year time extension to develop a container kitchen food truck cafe at 501 Pine Street. Is Mr. Schuele available, Scott?
I don't see Kurt in the attendees list. He does know that we're largely online. Oh, I just saw a hand get raised. iPad guest. I'm going to guess that's Kurt.
My guess is that this is marked for consent agenda approval. I just want to make sure that Kurt has no issues with it.
No.
Kurt, you've seen it. You're okay with it? No concerns?
No.
Is there anyone else here to speak on this application?
No.
Well, I'm asking the crowd writ large.
Oh, okay. Sorry.
I see no hands, nobody in the audience. All right, so with that, is there a member of the board who objects to treating this as a consent agenda item? Nobody? All right, I'll make a motion then. On ZP 21-800 501 Pine Street, we approve the additional 1-year time extension.
Second.
Jeff seconds. All those in favor?
Aye. Aye.
I got a full suite of hands. All right. Good luck.
Thank you.
Push the state.
Right.
The next item on our agenda is 565 Pine Street. Application of Michael Shea Jr., Michael Shea
Sorry,
Sr.
AJ. Maine. You said Pine.
What I said? Oh, 565 Main Street. I apologize. ZP 25277. Application Mike Shea Jr., Michael Shea Sr., and Tanya Chen. After the fact creation of 12-room boarding house, removal of existing stairway, replacement of 2 basement windows, and replacement of 3rd floor window. Is the applicant here? Or
my name is Sam Beal. I'm here representing Duncan Wisniewski Architecture on behalf of the client.
okay. Anyone else who wants to speak on this application? Please raise your right hand. Sam, I assume your hand's up. Do you swear that the testimony you're about to give is true and correct under the pains and penalties of perjury on this application?
I
do.
Right. Sam, why don't you walk us through?
AJ, can you hear me?
I can, Matt. How are you?
I'm sorry. I was muted. I did raise my hand. I'm not sure if you can see me because I'm not on the screen.
I hear you. I see your hand up. And you'd like to speak on this application too?
Maybe, but I did raise my hand, and if I have to, I'll participate. Thank you.
Okay, got it. Thanks, Matt.
Thank you.
Yep. So Sam, we can pull up plans, walk us through what's going on here and what you want to do.
Yeah. I think I'll keep it pretty simple because I think Scott's staff report is a pretty fair approximation of what has happened and what we intend to do. And so we have an existing use, a conditional use really, of a boarding house that in the city's database is a 5-bedroom boarding house. I'm not totally sure when the conversion to 12 bedrooms occurred, but that's currently how it's being used. Our office entered the building. We took measured drawings. We made recommendations to the owner as to how to bring this into compliance in terms of legal bedrooms. That's all within our memo to the city explaining why we're suggesting we need the new basement windows in particular to bring those bedrooms into compliance. And so with those improvements, we believe this meets the requirements with the zoning. I know Scott has a few findings. We accept all of the conditions that are in the staff report in terms of his recommendations. And we welcome the ability to move this project forward and get this building reconciled with what's currently in the city's database.
Was this spurred on by a notice of violation? Not that it's determinative, I'm just curious.
Yes, there's an existing lawsuit filed by the city against the owners based on, forget what you would call it. Sorry, I'm not a lawyer. Scott, can you
Zoning
speak to that
violation?
more? I believe a
Zoning
zoning
violation.
violation is the correct term. Thanks, AJ.
Expansion without a permit.
Okay, and we didn't see an appeal of that NOV. It just went final, and then I suppose there was an enforcement action.
I believe that's
maybe
the case. Yeah.
Okay. And Scott, would this solve that problem? Just trying to understand.
Yes.
Scope. Okay.
So I had one question or two questions for you, Scott. I didn't see in the document, in the staff's report, I know one of the conditional uses for boarding houses is owner occupancy. Does the owner live on the premises?
That's the representation, and that would
Okay.
continue to need to be the case.
Okay.
That-
And then
that is-
secondarily,
I can attest to that, Evan.
okay.
Yes.
And then secondarily, so it was called out that this doesn't trigger the bike parking requirements. But it looks like so it's going from 5 units to 12 units, which is a higher than a 25% increase. What reason did it not trigger the bike parking requirements?
It does trigger the bike
Okay.
parking requirement, and the
Is
bare
it just the long
minimum.
term that it didn't? I thought I was
Yeah.
reading in the staff report that it didn't.
I'm saying this without the code under my nose, but I believe the bare minimum is 2 spaces when any bike parking is required. The ratio for long term was less than a half, so I required a couple of short term spaces with a bike rack
Okay.
on site.
Okay. Sam, did you see the comment about a wastewater permit?
I did, and that is something that we will work through after this hearing in order to get that approved. You know, I see it similarly to getting the construction permit, which we will need to do after this for the actual work. We have Krebs and Lansing on board, as you can see on your screen there, and so Scott Homestead should be able to help us with the wastewater permit if necessary.
Okay. Any other questions from the board? Are there any exterior changes proposed as part of this? I didn't see any.
Yes, there's an existing stair. Well, sorry, there
I'm
was
sorry,
a
I meant
stair.
more site plan stuff, like expansion of parking or anything.
Oh, no, none currently planned. We do intend to follow Scott's condition around a barrier to make sure that the parking doesn't gradually encroach or gradually expand.
Okay. Any other questions from the board?
Yeah, I have a question.
Yeah, go for it.
So as part of your building permit, did they discuss or instruct you on what would happen in the third floor bedrooms as far as fire egress? Are you gonna have to sprinkler or anything like that?
The building is currently sprinkled.
Okay, good.
That's what triggered the ability to remove the old egress from the third floor. Unfortunately, we haven't yet rectified that by eliminating that door, and that's part of the scope of work planned now.
Anybody else? Sharon, you had your hand up, and Matt, you had your hand up. Matt, is there anything you want to add, or are you here on behalf of the Sheas? Scott, can you unmute Matt? Can I do that?
I just did. I can only ask him to unmute. There we
Can you
go.
hear me now?
Yep.
No, I was just raising my hand when the discussion was surrounding the legal status of the environmental court matter. But I think you're all set. If I can answer any questions about it, I'd be happy to. But I think you
Okay.
addressed it.
Sharon, you had some comments you wanted to make?
Yes, I did. Thank you. My name is Sharon Busher, and I don't live in this section of the city. I live up near the hospital. But when I reviewed the staff memo, it triggered a couple of thoughts. One has been touched upon, which is that one of the recommendations is to delineate better the parking on site and to create barriers so that it won't spill over. And my understanding from this, that the maximum number of parking spaces is 6, 1 for every 2 bedrooms. Scott presents the background information saying that this is in a neighborhood mainly with single-family homes, but there are some larger structures, and that it's been used as a boarding house and has had no impact. I just want to let everyone know that, you know, all of us live in residential neighborhoods, and when uses expand, and this has been expanded for some time, I'm certainly hoping that the parking impact can be accommodated by the property and not spill over and impact other people on the street and the potential for people to have visitors, etc. That remains a concern. For me, I had very much wanted, when I was on the city council, to have every property, when they came forward, identify the number of on-site spots that they made available. I thought it would be informative for the occupants, and I think it would be informative for the neighborhood and the city, understand just what the parking need is versus what the availability of spaces are. So I hope that works for the neighborhood. I understand the use has been going on now for quite a while, and it appears that there has been no complaint. So that's probably just something I wanted to highlight. My real issue has to do with something that I didn't quite understand. It has to do with section 3.5.6 under review criteria number 6, and it had to do with the substandard. I believe it's the basement units that are having the windows. Well, I know they're the ones that are having the windows replaced, but in the comments, staff comments, it says that will address some of the concerns, but it suggested that there were other concerns. So for me, I'm hoping that the DRB will make it very clear in their action and their recommendation that the basement units need to be approved for livability beyond just the addition of larger windows and more light and maybe ventilation. I don't know what the windows accomplish, but I am concerned about that. Had real life experience in Ward 1 where I live, where people occupied a basement apartment and suffered through mold and other problems trying to address it with the property management and really never did bring it to code and have it properly addressed. And there were health issues. So for me, the quality of life and the quality of the livability is really important. So that's the one thing I wanted to highlight and hope that that is adequately addressed. Once again, because I don't know what else is substandard in those units, I can't be more specific, but thank you.
Okay. Sharon, do you have is there a did you look at the staff report itself? Is there a
did.
particular way to restructure a condition in your mind?
Well, so when this, because this is going to have some renovations, code or the building inspector will come in. I don't know if the building inspector, Scott can answer that. I don't know if they have the same criteria that will address the substandard issues. And if they're going to be addressed at the time that they get their permit for occupancy, then it's fine. But if there needs to be additional language to ensure that those units, those substandard conditions have been completely addressed, then I would recommend language like that.
Okay,
I
I
wish
think
I
that
knew
is
more
part of our
specific.
standard conditions and how it is required because the construction has to meet the codes and receive a CO with inspection and closeout, but I do understand that.
Yeah, thank you. Appreciate it.
Hey, Jay, can I speak to the basement units briefly?
Yeah, please do.
Okay. So we walked the whole property, as I mentioned earlier, and we did go through the basement units, and the two of the three do not have the correct amount of light and ventilation as predicated in Chapter 18 of Burlington's Code of Ordinances. And that is the rationale behind why we are expanding those windows in order to bring that up to meeting code. You can see that actually
egress windows, right? They're not 44 inches off the
they're not for egress. That's something I want to be clear about. We have a sprinkled building here, and those windows do not need to satisfy for egress. You have the stairs to get out, and you have the sprinkler system that should quell any fire. And so the expansion of the windows is really there to create light and air to bring it into alignment with the Burlington Code.
And is that it has to be 4%, the window has to be 4% of the bedroom square floor area? Is that something like that?
That's correct. That's what if you look at the table up on your screen here, that is what we are demonstrating compliance there.
All right.
So I can't, in terms of Sharon's other comments about sort of the livability of a basement unit, I didn't observe anything untowards in terms of mold or other issues that you might see in a basement. It was clean and dry. The only deficiency I noted was that the windows were simply too small. So I'm hoping we can address that with this project.
Got it. Okay. So the basement, bedroom, 1, 2, 160 square feet. And the ventilation 4%. What is that, the opening of the window? Is that how we measure that?
That's how operable the window is. So with a double hung, if you satisfy
You got 3 by 2
and 4%, you're good. Yeah, exactly.
So it's got to be more than 4 square feet if it's 100 square feet. Got it.
Yep.
Okay. Are there any further questions or comments from the audience or the board? All right. Well, with that, I will close the public hearing on this, and I'd imagine we will deliberate on this later. The next item on our agenda is 172 North Willard Street. And 164 North Willard Street. The applicant has asked that they be deferred. If I'm correct on this, Scott, that they be deferred until the second meeting of August.
That's correct, AJ.
Yep. We have to set a time and place for a hearing within 60 days. And so we are at the point, Ms. Garrett, that we needed to conduct an initial, I think, notice the hearing and could defer it to later at the request of the applicant. I would recuse myself from the merits decision. However, I think procedurally I can participate in this since it's a deferral and it's a procedural issue. Does any member of the DRB object to deferring at the request of the applicant to the second meeting in August?
For confirmation, it's the request of the appellant, not the applicant, which is.
And I think the applicant opposes the request to.
Sorry, did I mix that? So.
Is it possible to clarify that we're talking about ZAP 25-2 right now, separately from 25-4? Because this is a appeal of an approved permit for an Americans with Disabilities compliant ramp, and we have a member of our household who's barely able to walk up the stairs right now, and it's really essential that we move forward with this. We do have the permission, but to delay it, it's already been 115 days since the appeal was formed by our neighbor.
That's
fair.
Thank you.
So there are two, let me clarify. There are two issues in front of us. ZAP 25-2, 172 North Willard Street. And I will focus only on that one for now, leaving the other one aside for later. 172 North Willard Street is an appeal of an administrative approval of an application to expand a rear deck with an ADA ramp along with a tool shed, front door replacement, and screen doors. All proposed site changes were approved on March 20th, 25. The appeal was completed on April 4th and is considered timely. The appellant, Mr. Purvis, has asked that the appeal hearing be deferred until the second meeting in August. Given that the applicant, the person with the permit approved, has opposed that, I believe that is a decision the DRB will have to make and decide whether they want to go forward with the hearing or not. I do see Mr. Purvis and Ms. Louderback online right now, and I will recuse myself from the determination and hand it over to my co-chair, Caitlin, and let you folks decide whether you want to hear this or defer it.
I think you've laid that out well, AJ, so I will let any other members of the board share their thoughts here.
Do we want to hear from the appellant? We've heard from the applicant as to why she'd like for it to go forward. Do we want to hear from the appellant as to why they are requesting a deferral?
Yes, that is a good suggestion. So, Mr. Purvis, I see you are unmuted if you want to share about, we're just focused on the deferral at this moment. Once we decide on that, we can move on to the merits, but the deferral of the hearing, can you speak to that, please?
Sure. Thank you for the opportunity to speak. This is a permit for an addition, and unfortunately, it's tied to a boundary line complaint that's links it to the ZAP 25-4 application as well. And so the primary reason for our request for deferral for this one is because there's two surveys that have made boundary retracement plats, and they differ from one another significantly and impact the way that you interpret the site plans. And we have attached a letter from our surveyor requesting more time so that he can work with the other surveyor to resolve the differences. And we think that by resolving the differences, a lot of the complexities and the contentions would be resolved ahead of time. And the surveyors are really the best parties to resolve those differences, and their intention to do so is important. And we would prefer for them to do that instead of having the board make a piecemeal decision impacting the boundary of one permit only to potentially later hear the other permit, and then maybe have to appeal the boundary decision because based on whatever the surveyors either do agree or don't agree upon.
I do want to be clear that this board does not have any oversight over boundary disputes or covenants for land. So while we use the best information available on boundary lines, the dispute itself is not something that our findings will have any bearing over.
Sure, thank you. And yes, and our goal when having the surveyors to kind of conform their differences is to present you a consensus best information available to interpret the site plan.
And when you had originally asked for a different date, I believe there was an inclusion of vacation time that you were unavailable.
Yeah, we're in Virginia on vacation, seeing extended family, and our vacation's been definitely impacted. And we sent Scott and Garrett just a screenshot that our internet connectivity is unstable, and so we hope we're coming through. But it's definitely disconcerting to be presenting on these important matters without the comfort of your home and the confidence of your connections.
Yep, we can hear you fine, and you haven't cut out at all.
Okay.
So just to give you that comfort.
I'd like to ask Garrett a question about in other DRB applications or appeals. Has the boundary line dispute ever? Is it typical that it would interrupt the process, delay the process at all?
In my time working here, I have not had a boundary dispute under one of my projects that have gone to the DRB.
Yeah.
I also, just clarity, regardless of the outcome of the boundary dispute, the question is whether, I guess, the question in my understanding is whether the deck is in the no build zone, which is not related to zoning, but a deed restriction. So would the boundary line dispute materially affect this for the side setback or anything else?
Is that for the 164, Luke Purvis and Christina Lauterbach? Is that directed towards us?
That's, the ones. I was just asking, I was having trouble following, I think, some of the requests, but it was on this boundary dispute. And so I'm just asking, I guess, our staff is, regardless of the survey, the side setback for this property is 5 feet, right?
So I can pipe in briefly, and Garrett can correct me if I'm wrong on the facts here. The ADA ramp is exempt from setbacks and lot coverage, so where the boundary is irrelevant unless it crossed the boundary onto 164, but it's far enough away that that's not the case. The edge of the deck is far enough away that even if the boundary is a foot or two further, I think north is that direction, it would still meet 5 feet. So I don't see the boundary being super relevant to this.
Sorry, this is Christina.
Hold on. I just
AJ
want
had
to
a
be
good
really
procedural
clear
point. Yeah.
that we are just talking about if we are deferring the matter or not. Evan, I think you're going a little bit into the merits.
Sorry.
which is difficult in this conversation, I understand, but since we haven't actually opened the hearing and sworn people in,
Right.
it is our first
This is
element.
This is Christina.
Okay.
May I just add, this is about the, oh, I'm sorry, Evan wanted to say something. That's okay.
Just we're following the procedures that we have for this meeting. So when we're ready for the appellant or the applicant to speak, I will let you know. But
Thank
as
you.
it stands within the board, I just wanted to be clear, what we are deciding on first is this request for deferral.
So if we vote not to defer and do it now, hearing the merits of the case, we can still vote to continue to a later date if we find that the evidence in the case is not sufficient to make a determination on the appeal.
We could, I
Right.
think, yes, right. That's my understanding.
Okay, since everyone is here, I'll make a motion. In that case, I will make a motion to not grant the extension for the hearing.
Second,
I heard the second from Jeff, is that right?
yes.
All those in favor?
Aye.
Okay, that looks like everyone. So with that, we will open the public hearing now to hear on the merits. So with this, because it is an appeal, we will start with the city. Before that, if anyone wishes to speak on this matter, it would be helpful if you use the raise hand feature in Zoom so that I can identify who needs to be sworn in for taking this testimony. So I'm seeing Melanie January as well as Luke Purvis and sorry, I can't see, and Christina Lauterbachs have raised their hands. So with that,
Also, Margaret Tamulonis is here with me. Yes.
thank you for
Thank
letting me
you.
know that.
Yes, thank you.
So if you would raise your right hand and swear that the testimony you give tonight is true and correct under pains of and penalty of perjury.
Do.
Yes.
Yes, yes.
Thank you. So with that, again, this is an appeal. Scott, this was Garrett's. You give a little bit of an introduction on this, but can you just give the city's position?
Yeah, so to keep it relatively short, the original zoning permit ZP 2583 was for the deck, the ADA ramp, a shed, doors, smaller other changes. The area that seems to be under appeal, under the most focus, is the new deck and ADA ramp. The deck addition as an accessory site feature, if it's under 15 feet in height, is allowed to have a 5-foot side yard setback. On the proposed plans, it was noted at 15 feet. The ADA ramp, which is closer to the property line, is exempt or is allowed to encroach into setbacks and was proposed closer than that, roughly around 8-ish feet, based on the scale of the site plan. Because of that, the application was approved, and only after approval and when the appeal came in was the information about the deed and a no-build zone provided along with the appeal.
Thanks. Just a procedural question, Scott, because we typically hear appeals from the property owner, but in this case, the appeal is from the neighbor. Would I go to the property owner before going to the appellant?
Typically, it's the city, then the appellate, and then in this case, there's a third party, the property owner, who would weigh in.
Okay, thank you. With that, any questions for the city before I turn it over to the appellant from the board? Okay, not seeing or hearing any of that. Mr. Purvis, if you wanted to share a little bit more about your piece, again, just a reminder that property disputes are not within our purview. So anything about how wherever that property line lays impacts the zoning applicability is really what is germane to the conversation.
Thank you. So first, just since we have the site plan up, there's a couple of deficiencies that we'd like to address. The first one is site plans are supposed to include easements. This one doesn't, and there's a history of this applicant's site plans not including the easement. There's a chimney on the building by the driveway, which is not depicted, that contributes to lot coverage. That should be depicted, especially because it would encroach upon the kind of the ADA route that will be taken. And so it's an important depiction to add since the ADA ramp is connecting to the driveway. And thirdly, according to their surveyor's claims, there is a concrete pad that has historically been on our side of the fence that is now should now be depicted on their site plan in order for their site plan to accurately represent what they're claiming. And so we'd like those elements definitely addressed as part of an accurate site plan for this project. So then additionally, the deck itself seems to be like unprecedented in our neighborhood, I would say. I think it's due to the increased lot coverages allowed from the upzoning. And so it's just something that's so large that we and this is a really important and private area of our adjacent to our house that's into like a private area where our bathroom and living room is. And so we were hoping to get a little bit of help with some design and design elements, like potentially with some screening or lowering the height of the deck because so it doesn't look into our windows and intrude on with our privacy. And then also, there's been a number of permits from this property recently, and there's been, to really kind of maximize what their development is in the property. And one thing that's been left behind is where the refuse containers sit. And so there's now 3 recycle bins and a trash bin, and those are oftentimes underneath our eaves and by our windows. And the property has a home occupation and stuff. So we just would love it if there could be a respectable, some livability concerns incorporated into the design, especially around the refuse and the height and of the deck and screening or buffering or lack of that, since it will be kind of oriented towards the south, facing the sun and looking into our house. But the kind of the most important thing and the reason for our appeal is there's 2 reasons. One is the deed restriction, which prevents buildings within 15 feet of the property line. And so that property line is unknown. So if the 172 survey is correct, then only the deck, only the stairs and the ramp would be violating that deed restriction. If the survey that we have commissioned is correct, then the deck and the ramp and the stairs all do violate that deed restriction. And so we wanted to use that deed restriction and address a comment in the city staff's in the staff report, which stated that in summary, there is no provision in the ordinance that limits development based on a deed. And we don't understand that to be actually factually correct. We understand that pretty much all the elements of the deed control what zoning allows for development. And it starts with who's on the deed. And I would not be able to apply for a permit at 172 North Willard because I'm not on the deed. the deed defines the location, which then contributes to the zoning district that is applicable, and there's different standards for different zoning districts. And the deed also contains measurements and the shape of the parcel, which is important to zoning in terms of lot coverage, and like there's the table and setbacks and the table that Garrett provided about, for what's available. And so all of those elements are based on zoning relies on the deed. And so to stop applying the deed and this restriction and enable this development is kind of an arbitrary distinction where that is inconsistent and not supported by the other ways that zoning relies on the deed. And so that's a big concern, because it's been something that's been respected and been there for 75 years, and it shouldn't, like, zoning to, these things projects are important to people, and when zoning is less restrictive than the deed and then allows stuff to go forward, then it creates unnecessary expectation that something should be allowed, and conflict, and so that's something that we would just, that we would ask that the board respect the deed restriction, because this addition specifically is built on piers that are tied to the height of the existing doorways. And so it's integrated in with the building. And so it's part of the deed restriction because it's going to be a permanent fixture. And we would also point the board to the land survey, the land attorney who provided an opinion about the applicability of the deed in regards to this specific addition. And finally, the last point is the 5.2 point. Let's see, it's the minimum, it's the provision that requires the minimum. It's right underneath the table of the staff report. Let's see, I'm trying to just pull up that provision. Anyway, it requires it speaks to a minimum. A minimum for an ADA, an ADA reasonable accommodation, and that would then, a reasonable accommodation is then exempt from lot coverage. And so we understand the slope of an ADA ramp to be 1 inch of descent per 12 inches of run. And so this, like the applicant has stated, that this is approximately about a 25-inch rise here. And so the ramp, according to the minimum requirement, should be 25 feet. And you can see how this particular ramp has 2 lanes and goes towards the backyard of the property first from the deck and then back towards the driveway. And so it's tough to tell because this application actually lacks any measurements demonstrating the minimum has been applied, but it looks to us like this is about 50 feet. And we think that if there's truly a provision that speaks to the minimums, the application ought to have calculations and demonstrations about how it has adhered to that principle, even though it doesn't count towards the lot coverage. And so that hasn't happened. And then if the button survey is correct, which is our survey, if you kind of scroll up to the very backyard to the top of the site plan image, there's a new shed that's going in. So like the 3rd shed in the backyard, and we believe this extra lot coverage was intended for affordable housing. So we're not quite sure why it's getting used for sheds and large decks instead of affordable housing. But if it's allowed, it's allowed. But what the problem is with the boundary dispute here is if the survey that we have commissioned is correct, that shed, based on the measurements, would be within inches of the existing shed to the left of it. Right now, with it relying on their surveys, it would, there looks like to be a little bit of a buffer there and normal spacing. But if that survey doesn't end up standing, then to maintain the 15 feet required by the deed restriction, which, they're definitely applying the deed restriction to the shed. So not quite sure why they're not applying the deed restriction to the addition to their primary residence. That shed would be within inches of the existing shed, which wouldn't make much sense for placement. So let's see.
So I think Lucas said a lot. This is Christina. Hi. We are not opposed really to this, this ADA ramp. But we do believe that the neighbors must follow the deed restriction and how deeds apply to everyone, no matter who owns it. And the CDO applies to everyone all the time. And so every part, including that a ADA ramp needs to be a minimum, applies to everyone. I think that those are our main concerns with this particular project.
And also, we would love, we're not opposed. The ADA accessibility is important, and we previously valued Lenny and Margaret Tamulonis, Meg's parents, as very good friends before this boundary dispute has kind of caused a fallout. And so we definitely don't want to do anything that would deliberately delay their ability to access their house. It's just that this ramp has been tacked on to the biggest deck available using all the rest of the lot coverage and encroaches into the 15-foot no build zone, which the shed is depicted to respect, but the addition isn't. And so that just seems to be inconsistent application of the same deed restriction within this permit.
Okay, thank you. Do any members of the board have a question for the appellant before we hear from the property owner?
Yes, when did you commission your own survey?
Hi, this is Luke again. So we commissioned previously, it was about 8 months to a year ago. There was a permit ZP 23560, I believe, from the 172 North Willard owners, where if you see at the driveway, there is a fence that encroaches, that goes perpendicular to against our house. And so the 5-foot setback, right, there's supposed to be a 5-foot easement for maintenance of our house right there. And so that fence was installed against our house without our permission. We've been here. We didn't have the survey ready at the time for that appeal. And it also violates our easement restriction because we can't maintain our house. And so this survey was completed, has just recently been completed, pending trying to get some records from the diocese just to confirm there's no discrepancy in historical records to what the interpretations are. So about 9 months ago, I would say, and it's been heavily researched to produce what has gone into it so far.
Thank you.
And one other thing is, if instead of a denial, we would very much be open to a revision and and a rediscussion of this. I think there are some pretty core pieces of the CDO that need to be addressed within here, and let's allow the small changes to happen. Hopefully, also respecting the deed so it wouldn't drive further appeal. And so that neither the applicant nor the appellant have to incur additional costs or timing delays in order to incorporate some relatively small changes and hopefully just some respect for the deeded restriction.
Thank you. Any other questions from the board for the appellant? Okay. I would like to now hear from the property owner. Melanie, if you would like to speak and share your thoughts beyond the materials that were shared online, which we have all read.
Sure. So I feel that it's important to mention at this point that there's been no desire to cause delay for, Lenny and Margaret. I just want to mention that we have a woman in our household, mid-80s, who is having an incredibly reduced ability to walk right now. And the 4 months that it has taken to get to this hearing has been unnecessary as far as I'm concerned. I'm a very big disability rights advocate. And when somebody is, at the, let's call it a third trimester of their life and faces the inability to walk on a walking surface out of the home, and the family wants to put one up and the neighbor appeals, that's very, very, very challenging for the soul and the members in the family. So when, we hear our neighbors don't want to delay this, it's already been delayed 4 months. And, I was actually, my own experience, I was in the hospital on March 20th for a surgery, pretty major surgery. And we got the approval. I'm like, yay, that's great. All that hard work. The deed restriction was something that the first time I talked with Garrett a couple of years ago, Meg and I were down at the, place, we talked about the deed restrictions and just trying to get an understanding. And we actually had a permit approved for our first shed 1, that was going to be in the setback, 5 feet from the setback, or 5 feet from the boundary line. And there's communication, just want to reference, from our neighbor who had no problem with it and actually encouraged, because of their fence and the property line, maybe we should put it up 7 feet from the property line. And there was no mention about a deed restriction for a freaking shed. And now we're having a very challenging time about an accessibility thing. And I also want to explain with the way that we designed our ramp or our deck was, we have a 7 by 20 foot deck right now. And that was what was allowed at the time that Meg's parents put the addition in. And when you kind of go from living on a farm to living in a 2-room home with a bathroom, and you have this 7 foot deck, that's really amazing, of a decrease in your independence. And when your mobility, changes, you're not able to walk across the yard. If you have a little bit of an outdoor structure, which is what we're designing, is 10 feet wide to go along our house, 20 feet along the deck, another 7 feet. So that's going to extend it out. Most of that's going to be a walking path anyway. The way that the deck ramp is designed is we are looking at, well, I also want to say that in 1949, when our home was built, it was built 15 feet, with the exception of the chimney, from foundation to foundation, 15 feet. And that's the deed restricted area. It was honored in 1949. However, in 2025, we're being told that it's got to be 13 feet there. So because of a new 2 feet that have been found, as far as surveys in the area, Luke Purvis had a survey in 2016 for Albert Harris, who was a land surveyor of 35 years. And on that survey, it depicted the property boundaries. And that survey went into, planning and zoning. It was referenced into DRB. It went to a settlement case with the Clearys, and that was appealed to the Superior Court and the Supreme Court. And, that survey, it's held the boundaries of that property. So I really question any, new submission of a survey today saying that that property is going to be larger, and which would also interfere with our, we want to honor the deed. We have a restriction, 15 feet of no building. Whether or not a ramp is a building, it's considered a walking surface by definition. And for the ADA design, if I think what Luke is presenting is that we have a 28-foot space, along the side of our deck, and it might be 20, I don't remember if it was 26 to 28 or 20, I don't know, it's around 25 to 27 inches high. And that's depending on the grade. If you walk in our yard, you walk uphill. So depending where the ramp comes out will depend on the height. You have to have, by ADA design, you have to have 5 feet at the bottom and 5 feet at the top. And any turn, you have to have 5 feet. So it has to be flat. So as somebody exits the deck, you can't just go down a ramp. You have to go onto a flat surface, turn in the direction that you're going to go, and then start walking. If you have somebody with very, very, very extreme mobility challenges, you really need that, you know, flat surface for safety. And that's how we accommodate it. I think the measurement is on there. Let me see if I could zoom in a little bit. Oops, I have a pop-up. I think it was 14 feet from the house is what I calculated. And again, this is a plan, and to be approved by permitting, we keep within the plan, which is to stick with the ADA design, run the ramp along the house to the driveway, you know, for accessibility, and then we meet the minimum standards. Part of the minimum standard is 1 to 12 inches, you know, grade, and then another part of the minimum standard is the 5 feet flat surface, and then the last part is a minimum standard of 36 inches between, you know, the railings on the bottom. So like if you have a wheelchair or something, or, you know, someone's walking along, someone with a walker, there's enough room. Burlington code, and I think this is what Luke was referencing, and I don't think I included it because, of course, if I'm out of code and compliance, that's going to be found. So, of course, you know, when I go to close out the permit, I'm going to build this thing, you know, with hope that it's going to pass, because I don't want to, with my own issues, to go back and redo it. That would be senseless. But it's that Burlington allows for lot coverage, the minimum, and the minimum is 36 or whatever on the inside. So like, it's not like I could make the thing, and they're talking about not the length minimum, but the width minimum. And like, if we had, you know, like a building in the back that was a home, we would probably have to ask for a, I don't remember the term, but like an exception to be able to get a walking path, you know, throughout the space that if we didn't have lot coverage. But we're not in that situation here. We're just asking for, you know, the accommodation for the, you know, ramp. And when you have like 5 feet, 3 feet, 36 inches, if you take 3 feet off, we're really looking at a 7-foot deck wide. But if you look at all of our doorways, and if somebody was needing that space clear, I mean, it's not like we're going to have a lot of furniture out there. We need to leave room for the walking space. But what that would do is allow our aging and disabled family members to be able to be outside, away from dog dug holes in the ground, and be safe. Be able to go look at the stars, walk out, look at the bats and all of that. And I think it's unreasonable. You know, I think when a person is putting something on their lot because of disability needs, it's unreasonable to like create a sort of you know, thing that they have to abide by in order to have this right, such as maintaining garden for the rest of my life to create privacy. That would be an expense that would be burdensome, you know, on fixed income. It might be limiting depending on like if I were maintaining something and I were having like heart issues, you know, or I would have to pay a gardener to maintain. I don't think that's something that should be, you know, required in order to have a disability related accommodation. I think that's unfair for, you know, to burden somebody with a disability to have that extra expense and responsibility.
Thank you. Does anyone from the board have questions for the property owner?
I have one, and I'm just basing this off the site plans. I haven't viewed current conditions, but has there been any exploration to kind of limit how much goes into that easement to do like before the turn? Could part of the ramp be on the east side? Like, was that explored at all in the plans?
When you say the east side, I'm not sure where you're talking about.
So the house, so basically kind of going towards the garden. So
yeah,
currently it's all on the south. And so
Again, with that sort of design, you would be asking a person with a disability to exert themselves more when they're already having, limited capacity to be able to exit their home and enter their home. So.
Any other questions from the board?
Maybe one, just so we're aware, is there any other ongoing litigation related to the property dispute?
Oh, no, there's nothing at all. Yeah.
Okay.
And also my partner, Margaret's here. I don't know if she wants to say anything for public comment, but for appeal rights.
Yeah, actually, I just wanted to say thank you all for listening to this and everything. And I think, I know I can't get into things too much, but I want you to really understand that this is just an added entanglement into our neighbors' continuing problems with the city. And I'm very distressed to be pulled into that. And all I'm trying to do is make sure that my parents and family are safe. Melanie hasn't talked much about her own needs, but she does have mobility needs as well. And I do feel like this, you'll hear about the fence next, and this comes directly from that situation. As soon as we questioned them about the fence, I was informed that they'll be bringing up complaints about our property thenceforth, and that is certainly what's happened all the way to environmental court, as you are aware. And at the time, I really wasn't concerned because I know that we work very collaboratively and carefully with city planning and zoning, but it's been very wearing over the past year now. And I want you to know that the situation is not just a bureaucratic burden. It's had a lot of human consequences. When my aging parents moved in with me almost 10 years ago, or more than 10 years ago, I hoped that they could live safely and comfortably in an accessible home near the medical center in the neighborhood. And after my mother's stroke, her mobility has declined significantly. And we'd hoped that by now we would have an accessible walkway for her to come out and enjoy the backyard. We really like our own backyard ourselves. So as I said, I'm also concerned about Melanie. And I know I've certainly been made very clear to me that Mr. Purvis is very distressed by the many improvements that Melanie and I are making to our property. We've heard from him and Christina through repeated emails, even signs placed in our own yard, verbal confrontations. We know he closely monitors our every move. And even a few weeks ago, I became aware of him literally crouching in our backyard at 5 o'clock in the morning. So it's been a very difficult time with this behavior. So please understand it's been a difficult situation. Thank you.
I do want to try to ask just that we keep details germane to the matters at hand.
Thanks, Evan. It doesn't look like we have any other questions.
And could I add something as well? Before you close, or I close my public comment.
Sure. Is this Melanie speaking again? For the record, I wanted to.
Yeah, this is Melanie for the record. Meg reminded me when I was sharing, I wanted to share that our permit was approved administratively while I was in the hospital, and I got out from having major surgery, and I got out with a walker, and for a couple of weeks I couldn't walk outside without my partner. So she would go to work, and I'm facing sort of this really big emotional feeling. It was my second surgery where I wasn't able to exit out of the house in the last couple of years on my own. But I had to use a walker, and I couldn't walk down the stairs and carry like a weight restriction. And it just really felt like how difficult, like I don't want to experience that feeling ever again, where I can't leave my home. And I mean, really, that's what this is about. And right, and that's what Margaret experiences Meg's mother right now. And the neighbor has commented about, like, the window wells being in the site plan. Happily put them on immediately. We are so happy to just put on the missing chimney. I mean, I see it every day. We have lot coverage for that. And if we didn't, we could bust up a little bit of the driveway in order to make this work. So I just wanted to mention that our willingness to, adapt our site plan is pretty much there. So thank you.
Thank you. I do see that you have your hand up, Luke Purvis. So if there is additional comment beyond what you've shared before that is, to the matter before us, we would happily hear that.
Yes, please. Thank you. So Melanie has raised the 2016 survey and implied that we're survey shopping. I just want to point out that the 2016 survey was specific to finding an easement on the southern side of our property related to a dispute with those neighbors about the same extra land that's in our block that had previously been undocumented. And their survey from 2023 and the survey that we've just completed are boundary retracement surveys, which the 2016 survey is definitely not, and not labeled as a boundary retracement survey. We understand boundary retracement surveys are specific to trying to find the original boundary lines of the property. And so the 2016 survey definitely did not do that. And when we provided the 2016 survey to Melanie and Meg, we at the same time sent them an email that said, hey, we weren't able to do the northern line because of the cost and because of we were informed there was a lot of complexity in that line to untangle. And we had actually been having a conversation with Meg at the time. Melanie wasn't a resident there yet. And Meg, when she installed the ADU unit that she referenced for her parents, had raised and said, hey, our contractors have informed us that your metal fence is actually encroaches, about 2 to 3 feet on our deeded line. And Meg and I talked about it, and Meg has previously supported our property 100% in regards to the dispute that was happening on the southern side. And Meg and I talked about it, and she said, hey, that metal fence has been there since before I moved in. And so really, even if there is something here, there's not really much we can do about it anyway. And so let's just let the sleeping dogs lay. And so unfortunately now that's no longer the case about letting the sleeping dog lay. Secondly, the depiction of the ramp in the site plan isn't fully accurate. It shows the ramp hitting the northern side of the building, and to us it kind of looks like it should be, or it hits the northern side of the driveway gate, and we believe it should be depicted as hitting the southern side of the driveway gate. And those inaccurate depictions have previously caused an appeal about when we were surprised that they had placed their fence against our home while we were away. And so accurate depictions are a really important thing for us because it helps us to understand what they intend to do and not be surprised after the fact. Our particular thing about the minimum was more due to the length of the ramp, not the width of the ramp. And one other thing that's a really sensitive area thing for us in this area is this is where we get water into our basement. It's the one spot where we get water into our basement, and it's been exacerbated since they've done their recent driveway work where they removed a portion of their driveway. And so the lot served for us, the 15 feet of our deed restriction is really important to maintain green space in there so that we don't have to incur water intrusion to give them a huge deck. And really they could get their access and maintain all their accessibility, still have a really nice deck and not just flagrantly disregard the deed restriction. Thank you. If there might be somebody named Adam Phillips in the board in the chat who has called in late, if you can see him, he is able to speak to he's able to speak to the fence line, so maybe that would be more appropriate for the next one, if since this isn't really about the boundary. There is a boundary dispute. We have somebody who wants to speak to the boundary dispute that's not one of the two parties involved, but happy to have him speak into the next one if that's a more appropriate one.
Yeah, unless anyone else from the board feels like that would be helpful in this matter. It sounds like that is more germane on the next item on the agenda. So for the board, are there any further questions that you would like any of the parties to address before we close this public hearing and move on to the next agenda item? Okay, with that, we will close the public hearing and move on to ZAP 25 4 164 North Willard Street, which is the appeal of an extension request denial and inaccurate site plan. Are there any new parties that need to be sworn in for this item? If you would raise your hand, that would be helpful. Not seeing any. Scott, yes, do you have a comment?
Sorry, just raising my hand.
Okay.
Is I hey, testify on this?
Not as staff, is that what you're saying?
No, it would be as staff. I don't have to, I won't worry about it.
We don't usually swear in staff, do we?
No, we don't, just in case.
Okay, so with this, just again, as a matter of order, we will start with the city since this is an appeal, and then it will go back to you, Mr. Purvis, for you to share your piece. So that is the order we will go with here. Is this on you, Scott, or is this Garrett as well?
No, this is mine. So the zoning permit, the subject zoning permit was approved in 2022. I believe it was May of 2022. It was for installation of a fence, modification of an existing patio, so it met the side yard setback, and conversion to green space of compacted area along the south side of the driveway. And it included a turnaround, provision for turnaround. So those items were reflected in a settlement agreement that resolved 2 pending appeals from Mr. Purvis that related to an original denial of the fence permit because of some site conditions, as well as a determination, an adverse determination about the compacted area on the south side of the driveway. So that's the background. So the permit was issued once the settlement agreement was executed. The fence has been installed. There are some photos in the packet. It's been installed for about a year, maybe a little bit longer than that. There has been some change relative to the patio, and there's a photo there too showing a tape measure on AstroTurf. It shows compliance with a setback with the fence as installed. The fence as permitted is a straight line back from the end of the house. The fence as installed jogs over a foot and a half to the north. The punchline here is that the fence has been installed. There's been no effort to address the south side of the driveway. Addressing the south side of the driveway is required under the settlement agreement, and staff feels that there's no basis for adding another year to this, right? The project's basically been, the project insofar as the applicant cares to install it has been done for about a year. There seems to be no basis for extending it by another year. Leaving the deadline as originally approved in May of this year enables the city to move forward with hopefully bringing the property into compliance with enforcement.
Thank you. What did you want the enforcement officer to speak on this as well, or is that only if we have questions?
Only if needed. Attorney Sturvant's on as well if there are questions.
Any questions for the city before we hear from the appellant? Any questions from the board? Okay. Luke, I know you've raised your hand a couple of times and put it down, but you are.
Thank you. We were trying to interject because we believe this was should have started with a deferral request for the ZAP 25-4, and that didn't actually happen.
Got it. My apologies for that. So the deferral request on this item, you wanted this seen for the same date, the second date in August, is that correct?
Yes, we had really hoped that, things with the same boundary could be heard at the same time to provide a holistic experience and to give, a single decision about what that boundary was instead of piecemeal ones. Piecemeal decisions are what has driven the accurate site plan problem in the ZAP 25-4 appeal. And so we're really, really worried about beginning a process piecemeal that does that again. And we, from experience, know that a couple extra months to really provide a complete record and an accurate record, which we don't believe is happening right now in this appeal, it can save many years on the back end and many, many thousands of dollars. And so the reason for our request for deferral, in addition to the boundary and that our surveyor had requested, more time to work out the differences, is that that we had requested, about 1,000 pages of records from the city beginning in March, and only received, we're told that they were available in June 24th, 3 weeks prior. And so we haven't had time to build our positions and incorporate those documents. And so we, we feel handicapped because Mr. Gustin has a belief with blinders on that the records, the actions that city enforcement has taken that we've directly experienced over 10 years are just completely ignored and not represented. In the staff report, if you've had a chance to look at it, it's full of allegations and conclusions that are not substantiated with any sort of record. And so we are asking for more time so that the city staff can actually provide a position that evidence supports what they're saying. And in particular, there's this settlement from 2022. And the reason that we're having such a problem right now is there's a section in that settlement, number 11, where the city has identified areas that it protected against enforcement. And so, and adjacent to the parking area of the driveway and the barn. And so we have been unable to document those areas that the settlement specifically protects against in future enforcement onto our site plan, and due to the permit administration that it's been linked to. And so the permit to close the permit, because it's linked to the settlement, we have to be able to meet the conditions within the settlement and within the permit. The site plan that was approved for the permit doesn't, for what, because, and it's on the screen here, you can see there's no site plan calculation. It's kind of, it's covered over. Whatever's there was a document intended to show that lot coverage didn't increase, which was a stipulation in the settlement. This is not a site plan. It's not the document we submitted to be a site plan. And so the more time, the settlement also contains this provision about good faith communication if disputes arise from the settlement. And we've never received a single response from Mr. Gustin or Attorney Sturdivant about what do they believe they were protecting from enforcement when they included that. When we were talking to the prior city attorney, Dan Richardson, who got promoted to the judiciary, we had been talking to him very vocally about, hey, why was a written complaint that described gravel deposited across more than one property? Did it?
Can I just ask a clarifying question on this? Because it feels
Sure.
like you're getting a little bit into the
Oh,
merit here.
okay, sure. Apologize. Yeah.
So my understanding is that you're asking for a time extension here to get additional documentation reviewed so that you can make your full argument.
presents,
Is that a fair summary of
Yeah.
what you're asking for?
Yes. Christina?
And I would say to hopefully engage in good faith communication, like the settlement says, with the city, and very possibly not need to even come back to the board.
And allow our surveyors to hopefully address, because in our site plan you can see so to hopefully address the problem, to reduce the boundary, to provide clarity on where the setback for the patio should actually begin, what the proper line was for the fence that was installed.
Got it. I think that I am clear. Miles, did you have a question?
Do we need to address the deferral request before we talk about the merits, like the previous?
Yes.
I will move to deny the deferral request so that we can focus on the merits of this case and hopefully resolve it.
Do I have anyone second that?
I'll second it.
Thank you, Jeff. Any discussion? All those in favor of denying the deferral request? I can't exactly see the room. We've got both of you in the room. Great.
Yes.
And then all those opposed? Sean, Evan, okay. That's 4. The motion carries, right? Counted correctly? Okay. With that, we can now get into the merits, and I apologize, Scott had kind of already gotten into the merits. So we would normally start there. I'm guessing, Scott, there's nothing else that you want to add at this moment?
I'll just pipe in briefly. So the fence has been installed. It has not been installed per the approved site plan. The best case scenario for Luke, as far as I can tell, is that the property boundary is actually far enough further north that he could seek an amended permit to approve after the fact what has been installed. But that has no bearing on extending the permit as issued.
Thank you. Mr. Purvis, do you want to share more into the merits?
Yes, I just need to ask Scott, how does he know?
Hold on.
Sorry.
Any commentary should be directed towards the board.
Oh, sorry. Yeah. We are curious how how do I ask this question?
How he's determined that the fence was not installed according to plan, because when we look at the picture above, we see a 5-foot depiction between the patio and the fence, and then the fence, the fence, there's a gap between our home and the purple line where we've represented the fence. And implicit in this site plan that's actually described in the settlement is a requirement that we would be removing the concrete pad that runs, that has historically been directly south of the old fence and is directly south of the new fence. And so that concrete pad, which we can see both before in the old photos and in the new photos, is an anchor point that hasn't moved. And so that is a really, is important to show the relative location from the old and new fence. Also in the western corner, which is on the right-hand side of this picture, there's pictures that show the new fence has been moved back approximately a foot from the previous metal fence posts that where the fence went to. And so the new fence is is further to the south and at that point than the old fence. And so it's explicitly within the old fence location. And the eastern corner, which is by the house, you can see there's a vertical jog right at the corner of the house that goes to the north that depicts the jog that our current that the previous metal fence had, and that the new wooden fence has. So to us, our fence is installed exactly to plan, is right there, is in the same exact, nearly the same exact spot as the concrete pad that we've removed, which anchors and provides the relativity. And so when we hear Scott say that we haven't installed it according to plan, we are confused. And one of the reasons that we wanted more time is so that he could provide that answer. And it's similar to his kind of accusation in his staff report that said the patio wasn't compliant. And the reason we've had 10 years of litigate zoning problems is because because the zoning manager hasn't identified the problems in the city process until too late. And so we were floundering, saying there's a problem, but couldn't articulate it because the zoning administrator wouldn't articulate it.
Also, we're here because we think that we need to have a clear and accurate site plan for the settlement. And as Luke mentioned, this particular, you can't see the whole picture, but it doesn't include calculations of our barn, our driveway, or our house. And so that does not follow the written directions on how to create a site plan set out by the DRB. And so we are having a conflict with our neighbors about property lines and site plans, and we don't have an accurate site plan to help support or even, prove us wrong, because this particular document in front of you is not an accurate site plan.
And the reason that we had asked that we needed to make a change on this site plan, and a site plan that a change that the 172 North Willard owners were allowed in their ZP 23560 permit that we previously discussed, because there they installed a fence across our easement, blocking our ability to access our home from the left-hand side of this picture, the street side of this picture down the driveway. There's an easement that runs the whole length of the property. That's for the purposes of maintenance. And so one of the reasons that we had asked for the extension, because that occurred, a year and a half, 2 years into our permit window, was to install a walkway between the fence and the patio that could take us to where we have depicted the jog on the corner of our house, and turn that into a movable panel, and so that we can regain the access to our home that our easement is supposed to guarantee, which we've been fenced out of because the 172 North Willard owners didn't provide the deed when they submitted that permit. And so that is some likely pending litigation that's upcoming in terms of somebody had asked about potential litigation. So because the 172 North Willard owners, they received a phone call when we identified the encroachment issue, and we emailed Garrett about it on the ZP 23560 site plan. They received a phone call. They received suggestions about how to accommodate and fix and address this error. And those are considerations that we have never received. And so what's happened is we have these changes that we like to make. We haven't been able to complete our driveway gate because of all of the all of the boundary line issues and the entanglement into the settlement. And, and so we still haven't finished our gate, and we would like to just move our gate from where we were planned to install it to better accommodate our needs. And so that's just a minor change within the fence permit itself. And we made those requests, while the fence permit was active, and it had been approved, just as the 172 North Willard owners were allowed to change their permit post approval and put in a revision. And so we're looking for the same opportunity that was given to our neighbors to extend this. And it appears that Mr. Guston and the city have predetermined that we have a violation where our fence is. Even though they haven't assessed our surveyor or the land dispute attorney who has looked at all the evidence and talked about how the fence should be our property. And so our request for deferral really arises from these changes that we've had to address after the original approval, so that we can our extension request for this permit is to incorporate those changes that have been allowed at 172 North Willard, and to finish the approved project plans that have been delayed by our inability to work with the city, the lack of good faith communication, the entanglement in the settlement, and just the seemingly predetermination that we are a problem property when we just can't receive even valid zoning standards from the people of the city staff that we work with.
I want a clarifying question just to make sure I understand the current site conditions correctly. So there's a fence depicted here by this purple line, and then on the northern property 172, there's another fence on that property. And so there's two fences next to each other. Is that correct?
That's most partially correct. There's the ZP 23560 is perpendicular to the house across our house across their driveway that prevents us from walking along our easement to maintain our home. The 172 North Willard owners have been approved to install another fence along our shared boundary in the backyard, and it appears that they want us to take our fence down and then for them to put their fence in, or they want to put their fence just within a couple inches of our fence. So there's a double fence there. I'm not quite sure why they want to put in why they look to put in that fence, because we had been working with Margaret Tamulonis, the owner, about this fence since about like 2014, when we had been taking down weed trees and working on the design elements. And we can provide text messages that show we met in the yard to confirm the string line placement where we were intending to place the posts to match where they previously were. And so we had really worked and communicated with her about this fence. And so her complaint about it now being on their property was really surprising because of the extensive communication we had going into it. And we'd still love to address the area to the south of, that Scott has brought up, but we're happy to keep focused on the fence at this point. And especially would love to hear what specifically how we have installed this that is inconsistent with the approved site plan.
And then there was one more thing. So you made reference to not being able to submit, or not an alternative site plan not being accepted, that you did try to submit. Is that included in the packet, or?
It should be. I think there's a response to ZAP 25-4 city staff. And so is that where it is, Christina, or is that?
I think it is.
I think we think it's at the very end of that document that shows what we had tried to submit, and that document in particular includes the areas defined in section 11 of the settlement that are protected from enforcement. And we wonder, for us, the protected from enforcement was something that we worked with Attorney Richardson to add, because we were very alarmed why a complaint about more than one property did not receive, both properties described in the complaint didn't receive a violation. And so he understood the legitimacy of that concern. And so he put in we're going to protect those other areas from enforcement because we haven't issued a decision. And so we question, like, if they're going to be protected from what is the need to protect these areas from enforcement if they are either approved by the settlement or compliant to begin with in the first place. There's no need to protect them from enforcement if they're either approved or compliant. And so what to us, we believe that, and based on the conversations we had with Attorney Richardson, that was to include, to allow the gravel on the easement to exist and the gravel in the 1968 parcel to exist. And the 1968 parcel is the rectangular box to the south of the barn. And so that's what we've added on to the site plan, because the settlement the city has signed protects them from city enforcement, and so they ought to be depicted within a site plan.
And then to make it more complicated, right? You can see there is this turnaround spot. And we have been told that we are not following the settlement because we didn't create the turnaround spot. That is not true. We created it, and then we accessed a part of the CDO, which I don't have the number of.
It's 5.3.2, which is the Bianchi provision. And in the Bianchi provision, it states that reconstruction is allowed when only a minority of the nonconformity has been destroyed. And so what happened was in 2022, Scott Gustin, the zoning manager, changed the interpretation of how the nonconformity that had generated many years of litigation was to be assessed. We had received a parking use violation. In 2022, he changed it to a lot coverage standard. And so by changing how nonconformities are to be assessed, he really altered the ability for the settlement to provide resolution and changed what the settlement does say, because now it has to be assessed under the lot coverage determination instead of the parking use determination. And the parking use, it clearly states not to park there. However, if there is lot coverage, allowed lot coverage by zoning, and an approved vehicle use, which is definitely in the settlement for the turnaround spot, which connects to the easement, which connects to the 1968 parcel, and is been described by many neighbors of having existed there since the 1960s, even though the zoning isn't going to allow us to say that, that this is one big non-conformity on that side. And so we've taken the opportunity, because Mr. Gustin will not engage in good faith communication with us and can misstart events. And is just trying to prevent our documentation of these areas that the settlement protected, that we've gone ahead and reconstructed the 2-foot strip area and returned it to its previous state, like the ordinance allows, while still complying with the settlement, being under the lot coverage that Mr. Gustin provided. And so certainly if the city wants to talk to us about that reconstruction, we would be happy to, and potentially we may not be accurate on how we've enacted that. However, we believe we are, and the only reason we have done this is because of how this permit has been handled and incorporated into the settlement, incorporated into it, which swapped swapped this document in, which wasn't our site plan, didn't engage in the good faith communication, prevented us from documenting the protected areas, the areas protected from enforcement. And so,
Mr. Purvis, can I ask you a couple of quick questions to try to get us back on track here? So we're talking about a time extension for complying with a permit that was issued.
sure,
That permit was issued after the settlement agreement, correct?
that permit was issued, that permit was released within the settlement condition, within the settlement.
And my understanding is that as part of the settlement condition, you were required to provide an accurate site plan of all of the changes on your property and how it complied with establishing that you met lot coverage. Do you agree with that?
Yes.
Okay, and this site plan that we're looking at, this is the site plan you submitted
No,
to meet that condition.
no.
No.
Where is the site plan you submitted to meet that condition?
Can you ask Mr. Guston that, because he's the one who made the choice to replace. So we submitted a site plan.
Yeah.
Okay, did you, when the permit was issued, did you appeal or otherwise challenge?
I did, but it was
that this was the site plan that was referenced in that permit.
this is the site plan that's referenced in the permit. But we're right here, we're questioning, where's the site plan for the settlement? There's no stipulation in the settlement that the permit site plan be the same as the settlement site plan. And so
I disagree, and we're not going to get into the settlement terms, but this is the site plan that was in the approved permit that we are talking about
yes,
today. Is that correct?
Well,
Is that correct?
Yes, that is correct.
Okay, thank you.
Can I hear your
There's a lot that
question?
we're getting outside of our jurisdiction. I know there are a lot of intersecting matters as it relates to your property, but as Jeff mentioned, what is in front of us is a time extension.
And an accurate site plan.
No, the accurate site plan is not in front of us. There is a time extension.
But we disagree with how the city, that we believe the DRB controls all aspects of permit administration, right? And so
I understand your position. I just disagree with it. So.
Given what is before us, I think we have the information that we would require for this. I do see that Adam's hand is up. Mr. Purvis, did you still want us to hear commentary?
I do, and I would ask for the board to request why the fence line is not in compliance with the approved plan.
Okay, Adam, if there is testimony that you would like to give on this, I think you were not sworn in before. Is that correct?
Right.
So if you would raise your right hand and swear that the testimony that you give today is true and correct under pains and penalty of perjury.
I do.
Thank you.
I don't know if everybody can hear me. I haven't used.
Yes, we can hear you.
Haven't used this in a while. I just wanted to give testimony about helping with the fence and installing the fence and tearing down the old fence on the north, the main fence part that's in question. I was in the process with Luke and planning and lining out and making sure that we were within the original property line, given the old fence that was there was probably there for, I don't know how many years, but very long time. And we were pretty sure to make it within, or even more so within Luke's property line, according to the old fence. And we had lined it up, installed the posts, and the posts were in over winter never a problem. Everything was fine. Everything was fine. It seemed until just a little, maybe when I found out there was an issue with their neighbors. I noticed, it was a while before they said anything, but the fence was constructed and the fence posts were installed. And obviously the fence post was basically the line of where the fence was going to be, and basically having no problems with that, as was my understanding. And so we felt we were, well within range of not coming into any property line disputes or anything like that. But yeah, I just had to say, I remember taking out the old fence, cutting old trees that were pretty large that had grown through the fence, and that's my testimony as far as being involved in installing and also taking down the old fence and everything seeming fine with the neighbors up until far after it was built. So yeah, that's all I can really share.
Thank you. I believe we have heard from all of the parties that wanted to speak on this matter. I did just want to check if the city attorney wanted to add anything at this point.
Good evening. Kim Sturdivant here, Assistant City Attorney. I certainly am available to answer questions regarding the agreement. What's before you is the time extension. And then this question regarding the accurate site plan. I think, as already alluded to by Board Member Hand, the site plan is an unappealed site plan attached to a permit that was part of, related to a settlement agreement. So it has a finality attached to it at this point. Anything in the future is a new application. It does not pertain to collaterally attacking a site plan that was unappealed. As far as, well, I mean, that's what's before you right now. There are other issues with the settlement agreement and that Mr. Purvis raised that I would say I don't agree with, but at this point, they're really not germane to the questions before the board. But certainly, if there are any questions that you have for me, I am available.
Thank you.
Welcome.
Any questions for the city attorney from the board? It looks like we do have the neighbor raising her hand to speak. Okay. Melanie, if you would like to speak on this matter, you are welcome to. You're still sworn in from the previous matter. I would just remind you, as the city attorney just stated as well, what is before us is the time extension request. There are obviously many interrelated matters here, but what we are reviewing is the time extension request. So any commentary, if you could keep it to that, would be helpful.
Sure, yeah. Thank you for that reminder. There's a lot of stuff involved in this. I just wonder at some point tonight if the appellant could answer the question why the longest board on the back of his newly installed fence that reads 69 feet 9 inches in length, and why the site plan says 66 feet, and of course his survey that was a condition of that was 65.05. That question, and in regards to this being held up for a variety of reasons. One, I would like to direct the board to, I think you're going to deliberate on this after the fact, to really look at the testimony that we did, the written testimony, sort of the timeline, there was a initial extension request that was denied. And that was denied on May 22nd. And I have a screenshot in there. It looks like crayon writing. It's pretty easy to find. And then also Scott confirmed that through email this week. And then there was another submission with more information, more reasons to extend. And I guess that I also want to point out that even though this isn't pertinent because the neighbor you know, is not gonna, or it was denied the additional site plan with the walking path and all of that. If you look at those measurements, it says the same measurement as 66 feet in the back, which would really, even a new site plan that he's wanting to propose is smaller than the actual fence that was built. I just want to point those. And I mean, I think what I'm saying is that as neighbors, we have been impacted by this fence being built on our property, and there are pictures showing the encroachment, some before and after. It's at the top of our document that we submitted today about this, and to please look at those photos to sort of see the feel. And there is a question about our surveyor having special meetings with Chris Haggerty. And that's not accurate. Our surveyor was contacted, let's see,
It sounds like that's probably getting a little bit outside of what's before us because the site plan again is not.
Okay, so what I want to share is that one of the reasons why Luke is asking for an extension is so that his surveyor could have more time to, you know, settle this with us outside of, you know, the property, outside of DRB and planning and zoning and all. And that's not something we're actually engaging in with our surveyor. We've actually asked him not to communicate on our behalf. And, you know, we've received a bill of $1,200 since Chris Haggerty contacted our surveyor. And that's really unfortunate. I am on disability and I have a fixed income and high medical expenses. But I just want to really assert that that is not something that we are in support of at this point. And I'm just looking here for a second. And I do want to mention with the cement block that's been mentioned, before the settlement agreement, there were, and this is in the written testimony, but I just want to mention it because it was mentioned in his oral testimony today. There's a site plan of the property at 164 North Willard with the cement blocks are like floating in their property. And they were kind of claiming, hey, this is like over here and over there. And it's actually not depicted on the site plan to where it physically is. So it makes sense that without going to the property and everybody measuring to make that decision, that it would have been included in the site plan. Remember the settlement agreement to be removed. So an alternative, if he doesn't want to remove that, he can always make the patio smaller and do that as part of the closed permit, you know. Thanks.
Okay. Any other questions, comments from the board? I believe we have heard from everyone on this matter. I don't hear anything else. Mr. Purvis, I see that your hand is up again. I just want to caution you that if you have new matters, especially on the time extension request that you want to address, we will hear those, but.
Yes, this is about the time extension request and particularly the site plan. And Melanie brings up a point as to why we need the time. Because the complaint about the fence being on their property came after this approval. And we have this survey that may dispute with what the actual dimensions of our property are. And so the measurement of 66 versus 69 is relevant to having more time for us to solve this boundary issue.
Right. That 3 extra feet was undocumented within our block. There's 5 properties. The deeds say 50 feet each. They're 200 and ours says approximately. The other ones say 50 feet each. That's 250. There's actually 252 and a half, 253 feet. And so prior to these 2 surveys, there was nobody knew there was 2 to 3 extra feet on our block. And once the B&G survey has given that land to 176 North Willard, even though their deed says it's only 50 feet. Whereas, and also seemingly, according to our surveyor, has a mathematical error where you do not wind up in the where you started if you follow its calls. And the implication is it puts their boundary through our home. And so
yeah, I think I understand the
so-
argument for the time
Right.
extension is because of that. The specifics of that, of what may or may not be found in that amount of time, is not really helpful to this conversation when we're just talking about the time extension request. You would like the time extension request.
yes, we believe that we would like the time extension request. We believe that if there's a boundary dispute, the neighbors have an ability to do that outside of city and not require city to act in order to do their boundary dispute. And so really this should be about making sure that we're treated the same way as they were treated, and they can we can definitely are seemingly most likely taking the boundary issue to the civil court because we didn't realize that they weren't engaging in the conversation about the error on their site plan or on their survey. So that's news to us. You know, we were just working on what our surveyor had been telling us, that their surveyor had left their firm.
Those details are
Yeah,
really beyond the
sorry.
scope of the discussion right
Yeah,
now.
yeah.
So, with that, Melanie, I'd really encourage you not to add to this discussion at this point. I think we have heard everything that we need on this matter, and we have heard from you. So if it is new on the time extension, I will hear from you very briefly.
Hi, this is Margaret, and yep, it's been a difficult time, and all I'm asking is that you please uphold the administrative decision. Thank you.
Thank you. Okay, with that, I am going to close the public hearing. That is the last item on our agenda, if I'm looking at this correctly.
Yep, that's the last item on the agenda. And we
Recording
will
stopped.
wrap the meeting up for this evening. We'll take the matters under consideration and thank you.